So I want to welcome everyone to the AMC Workshop Wednesday workshop. We're glad to have you here. I'm relatively new to this. My name is Ron Lee. I am a Zoom consultant, if you would, and I'm just going to help moderate, move things along. It's a well-designed program. I've seen the PowerPoint, so we're going to allow Brad and Jasmine to introduce themselves. But first, I'd like to talk a little bit about protocols for using Zoom. And number one, we have muted you upon entry because this is a webinar. It's view only, if you would. But once the presentations are finished, then we are going to make time for questions via the chat. So if you have questions that come up during the presentation, put them in the chat. And when we get to the end of the PowerPoint presentations and the discussions from our attorneys, then I'll call out the chat as they, in rank order, if you would, as they first come in. So there are times I have experienced where there's times where the questions are just too elaborate, too complicated for me in my layman experience. So I will open your mic and allow you to ask your question and maybe elaborate a little bit more, just so that we can have clarity and you can get the answers that you're looking for. With that said, today's meeting is sponsored by the Carlin Insurance Group, and we've invited them to come and do an introduction, tell you a little bit about who they are, but unfortunately, this is not a lunch and learn, so they've finished their lunch and they're off to their meetings, as I was told by Lou and Tyler. So we do want to thank the Carlin Group for offering a $50 Visa gift card for one lucky raffle winner. And at the end of the program, we'll announce who that is. So with that said, I'd like to introduce Jasmine Hale. And Jasmine, if you would like to just tell me when you want me to advance your slides.
Oh, we can advance to the next one.
Okay.
Thanks, everybody. I'm Jasmine Hale. Brad, say hi too.
Hello, everyone.
Brad is the managing partner of Angius Terry in our Roseville office. I'm one of the partners in the office. We've probably worked with many of you, so hello. Sometimes it's nice to put names to the faces. Brad and I have been practicing and representing homeowners associations for a very long time. Brad, I think in excess of 25, 26 years now. Me, 15. We specialize in construction defect litigation, homeowner litigation, certainly general counsel work for boards of directors. That's most of my focus. So there's nothing that really surprises us at this point, but we're friendly, accessible, and always happy to help and serve as a resource if nothing else. So if that, we can move to the next slide and jump on into today's presentation, which is about the new and important laws in HOA world that have been passed, and that we want to give you guys a sort of pathway on how your various communities can comply. So the first law that we're going to talk about is Assembly Bill 3182. This is rental restrictions restricted, of course. This was enacted last year by the legislature, and it took effect in January of this year. So this thing is on the books and enforceable. And it's important to have just a little understanding of the background on why this law is here, because it may help everybody to kind of wrap their arms around it. So you keep hearing affordable housing in California, and that we don't have enough. And you may ask, why on earth does rentals of units in my HOA have anything to do with affordable housing? Riddle me that, Batman. I'm not quite sure, but that's what this bill is actually about, is affordable housing. And the objective is to make rentals of units more accessible, easier, remove some of the hindrances. And the legislature behind this said that will help make more homes available, and more homes available somehow affects and helps rental affordable housing. So that's the context of this bill. So with that context, it's important to understand what it accomplishes, which is basically it removes it allows for rental caps, we'll put it that way. 25% or higher. So if you're an association that has a rental cap that's lower than 25%, this bill mandates that you change your governing documents. You're like, oh my goodness, is that what that actually does? Yes, it does. Other changes that you may have in your governing documents are things like a minimum occupancy or a minimum ownership period. You can't have that now. So people are just allowed to rent their units. You know, for years and years, Brad and I did amendments and restatement to documents. And one of the first things boards would ask for is, how do we get investors out of the community? And we would say, put a minimum ownership term in. So you got to own the unit for a year before you rent it out. Those now are out the door because of this law. Other things that are a little trickier, minimum lease terms. The law specifically says that associations can ban short-term rentals and have a minimum 30-day lease term. So some attorneys in the industry have said, okay, then only 30-day lease terms are allowed. It's not exactly how other attorneys have interpreted it. Other attorneys have said, well, there's nothing that expressly prohibits a longer term, like let's say 6 months, 3 months, a year. And so if it's not prohibited, it must be allowed. You know, falling in the middle is maybe not a bad approach to say, well, we definitely know 30-day minimum leases are allowed because that's what the law says. If you're going to have a longer minimum lease term, and maybe your CC&Rs have that, a 1-year term, you may want to include some sort of an indication that there's a hardship or that there's a reason why you need this longer lease term than 30 days to help sort of provide a buffer, if you will, or some sort of basis that's not because we hate renters, because that's how, you know, if someone were to challenge this may come across. Another couple things, accessory dwelling units and junior accessory dwelling units. Those are those granny flats and garage conversions, little lock-off apartments. Those are not considered rentals at all, ever. Again, I'm not quite sure why, but it doesn't matter why. It just matters that that's what the law says. And you and I and regular folks can kind of scratch our heads and be like, so it's literally a rental unit that's not included in the rental cap. Like, that's a head scratcher, but that is what it is. So now we get to some of the fun parts of the discussion. So Brad, I've just said that there's probably board members on this presentation that are going to have to amend their documents. How do we go about amending the documents? Because that's always a tough one.
Yeah, so this is a huge issue, and this is really the main thrust of this particular new law, and that is that first of all, let me say this, if you don't have rental restrictions, if you don't have rental caps, 25%, whatever it is, if you don't have minimum lease terms, you don't have minimum occupancy, you do not need to go ahead and amend your CC&R. So that's real important because we get asked that almost every day. You have a mandatory amendment to governing documents. That's only if you have the particular rental restrictions that are arguably in violation of this law. Then you need to go ahead and get those amended. And there are different schools of thought on exactly how to get that done. Because let me ask you everyone a question. If you've ever experienced a CC&R amendment process or a revision process, you know that it is difficult. It's not that necessarily that the owners are opposed to what you're trying to do with the amendment or with a revision. It's just that they somewhat apathetic. So that's really the common idea. I have in my career gone door to door with board members to try and get people to vote for this. And literally I'll come to the door and they'll say, oh, this is what you want me to look at. And they brush the dust off an envelope that they have not opened. So it's very difficult. We have a program that we put together that's been really popular that allows a board resolution for the non-discretionary provisions. Let's say that you have a rental cap of 10%, a 10% rental cap. There can be no, currently, right, your CC&Rs, there can be no more than 10% of the homes being rented. Well, Jasmine, that one's in violation of the law, right?
Absolutely.
Yeah, so you need to get that changed. And the law says it. You must change this. So we have a program in place that has a board resolution that allows the board to go ahead and do it and to get the document recorded. And it's really popular.
So, and that's important for boards to understand because, again, you may hear different things in the industry. And CC&Rs will normally say if you're going to amend them, they have to have ownership approval. And so what Brad's talking about is a resolution that says, well, the board just approved this and we didn't ask owners to approve it. And the reason why we've created that program, and a lot of attorneys have created similar programs, so know that we're not out here in a legal, we're not on a legal limb all by ourselves, is that there are parts of the Davis-Sterling Act, that's the law that governs HOAs, that do allow for boards of directors to amend without ownership approval certain things in CC&Rs that are unlawful. Now those have, applied to removal of racial covenants. Those are unlawful. But now it's unlawful to have, a low rental cap or an occupancy requirement or an ownership requirement. So those are also unlawful. And so on that analogous basis, we've said, well, let's follow that same protocol then. We'll have the board adopt a resolution. It's done at an open board meeting. It's all communicated to the homeowners. We get this amendment recorded. We mail it to them. Everybody's on the same level playing field of information. And at the end of the day, why it matters that the associations who must amend their documents do amend their documents is because there's a $1,000 penalty. And for some communities, that may not sound like a big deal. But it's the concept that the association would be in violation of the law and that there are civil penalties that the association can be sued for in court. You not only go through the penalties, you also pay someone's legal fees to litigate the issue. So compliance is mandatory, and it's important that there is compliance because of these financial penalties. So that's the skinny with AB 3182. Obviously, if you have questions, we'll take those at the end. And next, Brad is going to talk about AB 3088. Want to advance the next slide, Ron?
Okay, so now we have something that's a little bit off topic for community associations, so you would think. It is AB 3088 and the follow-up bill, SB 91. Both of these are now law. These are in the books, and they are amendments to a scattering of different civil code provisions. This civil code is the laws, the statutes in California that have to do with primarily non-criminal type of issues, civil lawsuits, and that's where you can find the Davis-Sterling Act. But these different provisions are not in the Davis-Sterling Act. And I'm sure all of you know that the Davis-Sterling Act is that group of laws that has to do with nothing but community associations. It's the community association laws. So these are around and near, but not within the Davis-Sterling Act. So AB 3088 and SB 91, that's basically the tenant eviction moratorium that if you've been a board member over the last couple of years, you have heard of this, or maybe just because it's been all over the news because of COVID. So this is a COVID law. These are COVID laws, and it's the Tenant Relief Act, but it is the eviction moratorium. So basically what these, in general terms, what these laws do is they give benefits to residential tenants in California and to a certain extent, residential landlords with respect to the pandemic. And in particular, what it does is it gives different rights to both of them. So what does this have to do with community associations? Well, there's basically two main thrusts. The first is that as associations and board members, you're going to have to enforce your CC&Rs against owners. And oftentimes it's not the owner who is misbehaving, right? It is the tenant. It's the tenant who's misbehaving. And ultimately, the best remedy would be that tenant just doesn't live in your community anymore. And so what these laws do is they they prevent to a certain extent, they can prevent to a certain extent the ability of the landlord to evict their tenants. Now, also, in addition to enforcing, some associations will get to the point of doing a non-judicial foreclosure of delinquent assessment liens. Does that sound familiar? If the owner doesn't pay their assessments, then, and I know this is rare, but ultimately the association could go ahead and they could lien and they could foreclose if an owner doesn't pay their assessments. Well, if the owner has a tenant in their home when they get foreclosed upon and the association becomes the owner, if in fact there's no third-party bidders, then the association can be having a tenant and it could have some difficulties because of these laws with respect to evicting that tenant. So how about some details? So basically what this law has been doing since last year is that it has been requiring landlords before they will, with their 3-day notice with the tenant. So that's basically the nice note to the tenant, you're not paying your money with that or performing in some other way. But when it comes to money, the association, the landlord must give them a declaration where the tenant can fill out and can say, I can't pay the rent because of COVID, because I'm unemployed, or just because of the effect of COVID. So let's stop there just to make something really clear. This moratorium, this eviction moratorium, it only has to do with a tenant not paying their rent. It doesn't have to do with a tenant misbehaving. If a tenant cannot pay the rent because of COVID, then this cuts the tenant a break. If the tenant is misbehaving, if they're violating, they don't get off the hook. They cannot point to this eviction moratorium. So that is super important to know. The moratorium doesn't affect that. Oftentimes, though, I know what you're thinking is, well, usually when the tenant's not behaving, they're also not paying their rent. So that's what I'm saying. It is a combination there. So at the 3-day notice, the landlord gives the tenant this declaration, and the tenant then is able to fill it out, give it back to the landlord, and then the landlord can not evict. They cannot evict. So the devil's in the details. So we're talking, first it started just from March to August. So March of last year to August. Now, then it got extended to January. Now, of course, got extended to the end of June. So during this time period, then if a tenant cannot pay their rent, then they cannot be evicted. Slight additional detail is that since January through June, I know this is a lot, all the tenant has to say is that they can't pay, they have to pay 25% of their rent. So they're not completely let off the hook. All right, now combine this with the federal law of, remember we have the big law where everyone got money and the states got money. So California has over $1 billion to go ahead and disperse this out of that amount to low-income tenants through this program. And it will pay landlords up to 80% of the lost rent, and tenants can get up to 25% of their rent. So a lot of details, but I think the bottom line, Jasmine, is that this is in order to try and alleviate low-income tenants when they're hit hard by COVID. And so it's going to last, it's to June, but a landlord can go ahead and utilize this for that time period until 2025. If that makes sense. But that's the law.
And I think an important takeaway for board members who may be grappling and struggling with scofflaw tenants that are wreaking havoc on your communities is that The association doesn't necessarily have to like sit on their hands during this period, that you do have enforcement tools. A lot of CCNRs will have provision that allows for the association to discipline tenants or to seek an eviction if they're violating CCNRs. And if you don't have that kind of provision and you're dealing with a wayward tenant, you may want to consider amending them so that you have that type of right. But just know that you don't have to stop the enforcement process. You just may need to be mindful. It could be delayed, but associations, when they've got bad apple tenants, it's not turn a blind eye just because, well, what could we do? That's generally not an appropriate response.
Right. They can't just say moratorium. You can't do anything to us. That doesn't work. That's important.
So next we're going to jump on to Senate Bill 326. And this is the Elevated Infrastructure Repairs Statute. It was actually approved in 2019. So you're like, whoa, why are we doing a 2-year look back here? I'll tell you why. It was approved in 2019 and it took effect of January 2020. And then COVID hit and a whole bunch of the world went sideways and a lot of people just kind of put this one out of their mind. So what is this about? It applies to condominium projects. So if you are a board member of a condo project, you need to put your little ears up and listen. If your condo project has elevated exterior wooden elements, and you're like, I don't even know what that is, but it sounds like a lot of mouthful and I'm just gonna put my ears up. Nope. Elevated exterior wooden elements are things like balconies, things like stairs, walkways. Those are some of the big ones. If it's wood and you have a condo building, this applies to you and it's a big one. And that's why we're gonna keep hammering this home until everyone knows it and has complied. So a lot of board members will say, I have stucco, I don't have wood. Oh no, what's behind the stucco? Brad, I think Brad and I could tell you, having gone through defect litigation on many, many projects, this picture is a good example. Just because you don't see wood does not necessarily mean that there is not wood behind the facade or the fascia. So if you have questions about whether you actually have wooden elements in your community, definitely talk with your AMC manager. Sometimes you may need to engage an expert to figure it out, but first you got to determine, do we have wood? If you're one of the communities that's a condo that has wood, then by 2025, so we're now 3.5 years away from that. So that time is ever getting closer. You have to obtain an inspection report from either a licensed architect or a professional engineer. And those are the only 2 types of professionals who can provide you with this inspection report. What's this report supposed to be about? It's supposed to analyze and evaluate, do a visual inspection, but a lot of those professionals may say, I need to do some destructive testing to really understand what's going on with your wooden elements. And the purpose of this report is for the engineer or architect to identify with 95% confidence what is the remaining useful life of these elements and what kind of repairs are necessary or recommended so that they can be safe and habitable and usable. So you'll get your report, and the report is going to identify, here's the remaining, this balconies has 3 years of remaining useful life. Those stairs over there are a danger and should not be used. So depending on the kind of repairs that the report may identify, it sort of puts you on 2 different timelines of when you have to make repairs. If the report says things are life safety concerns, you're automatically required to start those repairs pretty much as soon as you get the report. So you got 120 days. So think about that. If you've got a condo project and you've got these elevated wooden elements and there's some janky stuff in your community, you're like, oof, we are looking at some bills coming up. And that's why we're talking about this, because this is probably going to be a very expensive compliance bill for a lot of communities. It's not like everybody is out there, fixing balconies on an annual basis. They're expensive. Sometimes there's questions, is this the association's responsibility? Is this the homeowner's responsibility? Those all go into this because technically the statute says it's when the association is responsible for those elements that you have to get this report and go through this compliance. Brad and I could sit here for probably an entire day and talk about this statute alone. And well, if it's unclear if the HOA is supposed to comply, Brad, what do you think?
Oh gosh, this is really be used as a sword against an association, but as a shield too. Compliance with this is super important. So if there's any gray areas, you really have to do it, you guys. You cannot avoid this statute. This is a big money one. This is one where the personal injury attorneys are lying in wait. Furthermore, as Jasmine said, I've been working with associations for 27 years. I've seen the same associations age over those years. We're getting older. Our associations are getting older. Your balconies, your stairways, your walkways may not be what they appear underneath that stucco. This is really important, and you need to set money aside for it.
And so just know that the compliance deadline is 2025. So there is some time, but if you think about the sort of practical implementation of this, number one, getting quotes. Number two, once you've gotten your quote, securing that professional's time and availability. There's only so many of these professionals in the Sacramento and surrounding areas. So you sit there and you say, okay, well, I'd rather not be the last worm, the last chicken to try and get the worm. Costs are going to go up. So these are all things to think about. And then obviously the setting aside of money in order to actually comply. The good news is if the report doesn't identify any life safety issues, and hopefully that's not the case because those ones have got to be undertaken immediately, the rest of the repairs then get put into the schedule of your reserve study. So let's say your reserve study says there's 5 more remaining useful years of life on these elements. Then you would, as the HOA, say, okay, great, I have 5 years now to save the money for these repairs that were identified. So that's the other good part of this law, is that it doesn't mandate everything be fixed all at once. It mandates life safety things, and that kind of makes sense. The genesis of this bill was the balcony collapse from Berkeley several years ago that caused, multiple fatalities. And, certainly associations don't want to have that on their watch. The first lawsuit that I ever litigated when I was a puppy lawyer was a balcony issue. And the fella, he put his foot through the balcony one day, never told the HOA. And, that created a whole cascade of stuff many years later. And so, balcony issues are real. This is not just about balconies. So that's definitely something to keep in mind. So Brad, let's talk about some questions, because these are things that, certainly now more people are not totally COVID focused. They're starting to turn their attention to this stuff. So let's say that I get a quote from an architect who's just a lone architect, not associated with any general contractor. And then I get a quote from a general contractor that put an architect on staff, and the one quote is like this high and the other quote is this high. Is it okay if I do obtain a report from a general contractor who just happens to have an architect on staff?
Yeah, so be careful with that one. And that one sort of reminds me of when mold was gold, right? And that, so you want different inspectors that are going to do the work. So if you want to avoid liability, then you want to retain an engineer or an architect. And then when you do the repairs, then you take that information and to find out how much it's going to cost, then you can take it to a general contractor. Don't you agree, Jasmine?
Yeah, the intention behind the law was definitely an independence. There's nothing in the law that prohibits, a report being prepared by the company that may ultimately do the work. But like Brad's saying, just be cognizant of what you may get in that circumstance. Another question to talk about is, let's say that we're a townhouse community, and so we're all attached, but we're townhouses, and legally our CC&Rs, they were a planned development. Brad, do we have to comply with this law?
And so there's not a legal express requirement for this law. However, you want to protect yourself. And if everyone's going around, in my opinion, inspecting when you're a condominium, then it probably behooves you to also perform an inspection as well. And yet you have a blueprint. Jasmine, what do you think?
Totally agreed. I mean, the statute expressly applies to condominiums. I think that boards of planned development townhouses, when the HOA has the exterior, balcony and elevated infrastructure responsibilities, I think those boards that pretend like, oh, just because we're technically not a condo, we don't or shouldn't comply with this. I definitely think at least you should obtain a report. So, you can, as a board, say we've fulfilled our fiduciary duty, like we have examined the infrastructure, and if homeowners are the responsible parties, then you can pass along the information of here's the things you need to do to fix your balconies, and if they're HOA responsibility, then the association has a blueprint on how to fix them. So a couple other things. First of all, compliance. Once the 2025 first deadline has been reached, you'll have to do this every 9 years. So just kind of moving forward, boards need to start putting these inspections and balcony and infrastructure repairs on their budgets, probably a little bit more proactively than what a lot of communities may have done in the past. Certainly Brad and I have worked with some where they've never had that on their budgets, and now we're starting to tell them things like, oh, y'all are probably going to have to fix every balcony in your community. And there's a lot of communities that are like, oh, heavens, no, that just cannot happen. So how are you going to pay for this? And that's the big, tough question. Certainly, the more runway the boards give themselves and their communities, the better options you have. Whether it's increases in regular assessments, homeowners hate that, just in case you're wondering. There's imposition of special assessments, depending on whether, it's 5% or less of your gross budget. The board could just pass it. Typically, these kinds of projects are going to be over the 5% threshold. So then you would need to get homeowner approval. Homeowner approval for special assessments is a majority of the majority. So majority of a quorum, that's what the statute calls it. So a lot of times homeowners don't like voluntarily assessing themselves. This is not our first rodeo. We're very aware of that. There are emergency assessments. That is something that the board of directors is simply allowed to pass no matter the size, but they have to meet certain statutory requirements. Maybe it's a court order. Maybe it's a life safety issue. So again, if you get your report and it says life safety issues and you're flat broke and don't have much money in your reserves, and your homeowners are like, we're never going to pay you an assessment to fix this, the association would have a legal basis to fix those emergency issues. You could borrow from reserves. That's certainly a possibility, but that's kind of like robbing Peter to pay Paul, because you've got basically a 1-year borrowing, and then you have to figure out, like, the intention is you repay the borrowed reserve money in a year. You can certainly spend from the reserves. If you've got money in your reserves, you should spend it. So that's something. And then loans. I've been working with a community in the Oakland area. they just went and got approval. Was a lot of effort on the board's part, but they had to get a $3.5 million loan so that they could effectively comply with SB 326, because there's a hot mess of balconies and elevated infrastructure in that community that require repair. And just know that you can do a combo of all of those things. It's not like if we do some reserve spending, you've foreclosed all the other options. And sometimes I think boards can get a little panicky in thinking that they have to pick one lane and that's the only option that they have. And the reality is there is a multitude of options, but you know, the best thing that Brad and I can recommend to the board members and to homeowners is, number one, start looking into this now. If your community is required to comply, the earlier you start, the better your options are. And number two, educate your homeowners, like over communicate on this stuff, because the last thing that they want to hear 3 years down the road is, oh, by the way, we've known about this. We've been doing a lot of things on our end. We never told you this is coming down the pike. And then they, you know, recall the board and say you've mismanaged things. So education and foreplanning will help alleviate a lot of the headaches that are likely to arise from the statute.
Yeah, you just can't, we can't stress that enough. You don't want to have to depend upon the emergency exception for the board to go ahead and raise assessments or impose a special assessment. If in fact you do the inspection and you find out you have to do some repairs right away, that I think that falls, you know, squarely within for the exception. But otherwise, you're just doing yourself a disservice. It's going to be bad enough that the association is going to need to impose a special assessment in that case. And it just tastes so much worse to your owners if the board is their own will, rather than having something like Jasmine said, where there's education, where you're taking your time, where you're getting bids, rather than rushing through something.
And the last thing that boards should be mindful of is, you know, certainly the government agencies with oversight are responsible for enforcing this statute, but there's going to be different levels of compliant, like we'll call them compliance guardrails from other sources. Insurance carriers are increasingly going to require the boards to comply with this. Why? Because that's part of their underwriting and risk. I mean, think about it. Now that this is a law, the underwriters and insurance carriers know this. I can tell you with pretty good confidence that projects that have their reports are probably going to get better premiums than projects that haven't received their reports. I mean, it just makes sense from an economic standpoint. So, you know, and I mean, it was certainly an issue that came up in the project that I just referenced with the $3.5 million loan and emergency assessment. You know, their insurance carrier dropped them a year ago and was like, yeah, your infrastructure is a hot mess and we want nothing with, you know, insuring this property. And so, you know, it's a trickle down effect. So just know it's not just government agencies that are going to be monitoring compliance. It's probably insurance carriers. It's your managers at AMC. It's your legal counsel. And it'll take a village to get this one underway, but it really does have a good intention behind it and an important one. So that concludes the, you know, Brad and I talking to each other part. So now we're going to open it up for the Q&A. And Ron, let her rip.
Absolutely. Thank you very much. So we'll start at the top. And the first question comes from Peter Pasteur. So it's a lengthy question. So I'm going to ask Peter if he wouldn't mind explaining that. So Peter, let me open your mic. And as soon as I find you, there we are. And you'll have to unmute yourself, Peter, and then ask your question if you would.
Okay, so thank you for taking this. Over the years, AMC has brought in many attorneys with good ideas to include in our CC&Rs. As boards change, some of that knowledge is lost. Does AMC keep track of those things that lawyers have recommended to the homeowners associations to include in their CC&Rs when they do updates?
Well, I don't want to answer for what AMC tracks, but I can certainly tell you that when, you know, AMC, when one of the managers reaches out to, you know, our office at Angius and Terry and says, hey, we'd like a quote on restating GovDocs, all of those recommendations, we're constantly updating and evolving what we recommend, and all of our restatements will always include all of the recommendations sort of on an accumulated level. And, you know, they are consistent and compliant with the current laws. They include recommendations on best practices. So yes, that's something that can't promise. I'm confident that AMC, you know, when they engage proposals from council, it's on an assumed basis that it will include all those recommendations.
Thank you. Thank you.
Okay, just to reference a previous question, PowerPoint slides will be made available. So we'll send those out. And Melanie has two questions. So Melanie, I'm going to allow you to ask your questions. And please unmute yourself.
Great, thank you very much. I was seeking some clarification on SB 326, the elevated infrastructure repair. Our community is a townhome planned unit community, and I'm sorry my audio cut out when you were speaking to that application of this bill. So just wanted to clarify if our association is responsible for inspecting balconies, elevated balconies that would be in interior areas of the townhomes that are not publicly accessible or not part of the general area in the community.
Well,
You're cutting out.
Yeah, York. Hold on one second.
Explained is that, so do you want to answer, Brad?
Yeah. So only condominiums are required to comply. Only condominiums are required to comply with this, but we recommend that all associations, townhomes, those with the balconies, walkways, stairways, that the association is required to maintain, that they should go ahead and follow this blueprint. We think it's a way to avoid liability. And you don't want that target on your back. But to be clear, the statute is just for condominiums.
Excellent. And Melanie, if I may, you had one other question, please, for clarification.
Actually, I think the question has been addressed.
Okay, so townhomes versus condos. Okay, excellent. Thank you so much. And Lynn has a question, just confirming that she heard correctly. Exterior, not exposed, is stucco we still need? And Lynn, let me open the mic to you so you can elaborate. Make sure I'm opening to the right Lynn. Okay. Please unmute yourself, Lynn.
Sure, I heard correctly. So our buildings, and I do believe we are a townhome association, the exterior is stucco. We don't have any balconies that protrude from the exterior. Any balconies are flush with the exterior wall. So my balcony is not accessible by anyone else. So I just am trying to make sure our exterior is stucco, but I think Jasmine said, even though the exterior is stucco, there's still wood behind that, which in my mind, if it's behind the stucco, it's not exterior, but.
Very good question. So number one, you would want to confirm whether you're a planned development townhouse or a condo. And to Brad's point earlier, in either case, we do recommend that those boards, consider compliance, even if you're a planned development. But the exterior elevated wooden elements, it means outside of the building. So it doesn't matter if it's not accessible from other units. It could still be, it's still considered exterior. It doesn't matter if stucco is over top of it. it's still exterior. It's basically anything that's not inside a unit is considered exterior for purposes like for normal people to wrap their arms around this. So it's not about, oh, well, no one has access to my balcony but me. It's about whether the balcony is wood or not. And sometimes you may not be able to see the wood, but it still may be the structural elements underneath what's holding your balcony or your elevated improvements together. That a good way to explain that, Brad?
Yep, that's it.
So unless the building's metal, everyone needs to comply, regardless of whether it's a condo or a planned development townhome. Is that my understanding?
Sort of, yes. Again, we want to make it clear, planned development townhomes are not required to comply. Condominiums, absolutely yes, unless you're a metal condominium structure, or you could be brick or stuff. I mean, you know, if there's wood in your building, you got to comply. We'll put it that way. We recommend that planned development townhomes, we recommend that they at least obtain the reports and work with your respective legal counsels, because you may have different who's responsible for the repairs, but we do at least recommend that the boards get reports.
Gotcha. Thank you so much.
You betcha.
Okay, and I'd just like to open it up to any other questions before we move along. Looking for the chat. Are there any other questions? It doesn't appear so. I'd like to just kind of finish up with a little housekeeping, if I would. I didn't mention earlier that Dwayne Williams asked me to moderate today because of his recent run-in with the medical profession. And so he is on light duty, staying at home, and asked me if I would do this in his behalf. So happy to be here. Also, Lou from the Carlin Insurance Company is sponsoring this event, and so the Carlin Insurance Company has provided AMC with a $50 Visa gift card, and I believe Jasmine is going to announce who our recipient is.
Betcha. Thanks, Ron. So the lucky winner today is Lynn Corey. You're going to get the $50 gift card. So thank you so much to Carlin Insurance for sponsoring this, and I'm sure Lynn is super excited.
I heard her. She was very enthusiastic.
And she says wahoo in the chat as well. So Brad and Jasmine, thank you so much. You guys were awesome. This is new to me, but I live in a homeowners association, so I can appreciate everything that you're saying. And last call for any other questions before we close the session. And it doesn't look like there is. So again, we thank you very much for sharing your knowledge with us today. And I think we're ready to conclude.
Okay.
Thank you.
Okay. And for everybody who attended today, thank you so much. And feel free to reach out to AMC for additional information.